Hello friends, welcome to Law and GK. So friends, on this channel we discuss the contents of law and previous year papers of judicial services and other legal exams. So friends, as you know, AIB examination is about to come and उसी के लिए हम ये videos ready कर रहे हैं. And if you have seen my previous videos, we have already discussed all the question papers available of AIB All India Bar Examination. In today's video, we are going to discuss all the questions of Evidence Act. आई होप कि ये वीडियोस आपके लिए बड़ी यूजफुल रहेंगी. सो फ्रेंड्स, इफ यू आर प्रिपेयरिंग फॉर जुडिशियल सर्विसेज, दिस चैनल विल बी वेरी यूजफुल फॉर यू. आपके लिए बड़ा ही बेनिफिशियल रहेगा. Next 35, which of the following is irrelevant fact under the Indian Evidence Act? Facts regarding motive, these are relevant. Regarding statement without related conduct, these are relevant. Regarding statement clubbed with conduct, yes. Facts which make other relevant facts as highly probable, these are also relevant. They are asking about the irrelevant fact. So all are relevant. If it is mentioned improbable, then D would be the answer. Answer is mentioned as D, but it is not correct. Next 36, test of competency of witness is her being intelligent, must be major, understanding the nature of question, capable of understanding the nature of question and giving rational answer. Yes, D is the answer. Next 37, which one is exception to the rule of hearsay evidence? DD, yes it is. Fact forming part of same transaction, it is also proof of alibi, no. Fact regarding character of accused, no. So A is the answer. B is also the answer, as justa is also an exception to rule of hearsay. Admission, confession, DD, register, they are the exceptions to the rule of hearsay. Next 38, communication between husband and wife is treated as privileged if communication was made during the marriage with promise of confidentiality, no. Only communication is required, promise is not required. Without promise of confidentiality, yes. Was made before the marriage, no. During the marriage होना चाहिए. B is the answer, mentioned in section 122 Evidence Act. Next 39, leading question can be asked even without permission of the court during cross examination. B is the answer, it is mentioned in section 143 Evidence Act. Next is 40, what do you mean by word evidence? Every fact connected with case, fact introduced in court of law, both. D is the answer, with the definition mentioned in section 3 interpretations in Evidence Act. Next 41, what is fact in issue? Fact involves indirectly या फिर necessary fact to arrive or determine the right, liability or immunity. B is the answer. This is also mentioned in interpretation in section 3 Evidence Act. Next 42, relevant fact is logically relevant to any fact in issue या फिर legally relevant. Legally relevant होना चाहिए. B is the answer. Next 18, which are the provision under the Indian Evidence Act that deals with relevancy of opinion of expert? That is 45, 46. C is the answer. Next 19, the contents of document may be proved either by primary or secondary evidence. A is the answer. Where is the provision in section 62 and 64 for primary and 63 and 65 for secondary evidence? Next 20, oral account of the contents of a document given by some person who has himself seen it is secondary evidence. D is the answer. This is mentioned in section 63 of Evidence Act. Next 21, the DNA test cannot revert the conclusive presumption envisaged under section 12 of the Evidence Act. The parties can avoid the rigor of such conclusive presumption only by proving non-access, which is a negative proof. It was so held in which case? In Sheikh Fakhruddin versus Sheikh Mohammed या फिर सिद्धा रमेश या फिर कैलाश. A is the answer. Next 22, the statements of dead person are relevant under which provision? In section 32, and it is mentioned here 4. Again it is mentioned wrongly here. So section 1 is there. C is the answer. Next 23, witnesses are the eyes and ears of justice. Whose statement is this? Bantham. B is the answer. Next 24, an accomplice is unworthy of credit unless he is corroborated in material particular is a ये क्या है? प्रिजम्पशन ऑफ फैक्ट है, कहाँ मेंशन किया गया? सेक्शन 114 ऑफ एविडेंस एक्ट। ए इज द आंसर। Next 25, patent ambiguity in interpreting document render it incurable. इसको ठीक नहीं कर सकते, क्योर नहीं कर सकते। बी इज द आंसर। Next 11, presumption of law is discretionary and rebuttable या फिर mandatory irrebuttable. Presumption of law is mandatory and irrebuttable. C is the answer. Next is 12. In Selby's case, Supreme Court of India examined the constitutionality of the tests like narcoanalysis, polygraph, brain mapping on the touchstone of Article 20 का 3 and 21. A is the answer. This is a repeat question. Next 13. According to the Law Commission of India, 69th report, Section 27 of Evidence Act is based on the doctrine of confirmation by subsequent event. C is the answer. Next is 14. Section 99 of Indian Evidence Act says person who are not party to the document or their representatives in interest may give evidence of any fact tending to show a contemporaneous agreement varying the terms of the document. This is based on the principle of pacta tertiae nec nocent nec person. And what is the meaning of pacta tertiae? A treaty binds the parties and only the parties and do not create obligation of third state. Pacta means contract or agreement between parties. Pacta tertiae nec nocent means tertiae means third party is not a party to the agreement or contract or the treaty. Next 15. Burden of proving that a person is alive who has not been heard for 7 years is on whom? Who affirms it? Obviously B is the answer. Section कौन सा है ये? This is section 108, presumption of death in Evidence Act. Next 16. The court's discretion to permit leading question is confined only to matters which are introductory, undisputed, facts already sufficiently proved to satisfaction of the court. All of the above. D is the answer. Next 17. The question is whether A murdered B. Marks on the ground produced by struggle at or near the place where the murder was committed are relevant fact under section 7. A is the answer. This is illustration B in section 7. This is 18. Section 93 of Evidence Act treats the patent ambiguity as incurable. B is the answer. Next 31. Evidences to document unmeaning in reference to existing fact is called as latent ambiguity. Patent कौन सी होती है? जो prima facie can be seen on the document. This is B. B is the answer. और कहाँ पर है इनके बारे में, कहाँ लिखा हुआ है? in section 93, 94, 5 of Evidence Act. Next 32. Original document is the best evidence. Exception to this rule is contained in Banker's Book Evidence Act. C is the answer. Next 86. Rabinder Kumar Pal at Dara Singh versus Republic of India is a famous case coming under section 30 Evidence Act, is also well known as. Next is 7. Selvi's daughter Kavita had married Shiv Kumar of a different caste against the wishes of her family. Shiv Kumar was brutally killed in 2004 and Selvi and two brothers became the suspects. Since the prosecution case depended entirely on circumstantial evidence, it sought the court's permission to conduct polygraphy and brain mapping test on 3 persons. The court granted the permission. Test was conducted. When the result of polygraphy test indicated signs of deception and the prosecution sought the court's permission to perform narco-analysis on the 3 persons, the magistrate directed that 3 undergo narco-analysis. All of them challenged this decision in the Karnataka High Court but failed to get relief. They went to Supreme Court. The court held that compulsory brain mapping and polygraph test and narco analysis were in violation of Article 20 का 3 and Article 21. ये बिल्कुल ठीक है. फिर देखिए बाकी ऑप्शंस हैं आर हेल्ड वैलिड या इन वॉलेशन ऑफ आर्टिकल 20 का 1 नो. फिर मैं अपनी पोलीग्राफी एंड नार्को एनालिसिस वॉलेशन आर्टिकल 14 नो. ये था ए. ए इज द आंसर. और ये केस कौन सा है? ये सेल्वी वर्सेस स्टेट ऑफ कर्नाटका. Next 31. The presumption of continuance of life is contained in section 107 of Evidence Act? A is the answer. 108 में क्या है? Presumption of death. And 32, testimony of a witness to the existence and non-existence of the fact or facts in issues is our direct evidence. C is the answer. And 69, A sees B running away from a room and afterwards sees C lying down in a pool of blood in the same room. A's evidence in as far as seeing B running away is direct, but as far as the murder is concerned, it is just circumstantial evidence. B is the answer. Next 70, a statement made by an accused person before the trial begins by which he admits to have committed the offense but which he repudiates at the trial is known as कौन सा कन्फेशन है? एक्स्ट्रा जुडिशियल या फिर वॉलंटरी? नो, इट इज रिट्रैक्टेड कन्फेशन. सी इज द आंसर. नेक्स्ट 71, एक्सपर्ट ओपिनियन अंडर सेक्शन 45 इज कंक्लूसिव प्रूफ है? नहीं है, ये नहीं है, बट ओनली सपोर्टिव एंड कोऑपरेटेड इन नेचर है. सी इज द आंसर. तो अगर लिखते ना नॉट अ कंक्लूसिव प्रूफ, ये भी ठीक है, बिल्कुल ठीक है ये, बट इसको अगर ऐसे लिखते नॉट अ कंक्लूसिव प्रूफ बट सपोर्टिव एंड कोऑपरेटिव इन नेचर, दोनों ठीक हो सकते थे. फिर ये यहाँ थोड़ी सी गड़बड़ कर दी ऑप्शन बनाने में. नेक्स्ट 86, लीडिंग क्वेश्चन कैन बी आस्क्ड ड्यूरिंग क्रॉस एग्जामिनेशन. ऑब्वियसली सी इज द आंसर. कहाँ मेंशन किया गया? सेक्शन 143 ऑफ एविडेंस एक्ट. नेक्स्ट 87, एस्टॉपल इज अ रूल बाय विच अ पार्टी टू लिटिगेशन इज आर स्टॉप्ड फ्रॉम असर्टिंग और डिनाइंग इफेक्ट. बिल्कुल ठीक है. प्रिवेंटेड फ्रॉम अपियरिंग पर्सन, प्रिवेंटेड फ्रॉम हाइडिंग एन एविडेंस. नो, A is the answer. Provision का section 115 of Evidence Act. Next 88, under section 122 of Evidence Act, a communication made to the spouse during marriage remains after the dissolution of marriage by divorce and but not on death. Remains privileged after dissolution of the marriage by divorce or death. D is the answer. Next 11, Indian Evidence Act applies to proceedings before tribunal. No. Arbitrator? No. Judicial proceedings in court only. C is the answer. Next is 12, fact in issue means fact existence or non-existence of which is admitted by the parties. No, वो disputed हो गया ना फिर. Disputed by the parties. B is the answer. Next is 14, the conciliation proceedings can be used as evidence in any judicial proceedings. या फिर कैन नॉट बी यूज्ड एज एविडेंस. कैन बी यूज, कैन बी यूज, कैन नॉट बी यूज्ड एज एविडेंस. डी इज द आंसर. और ये कहाँ प्रोवाइड किया गया? प्रोवाइड किया गया सेक्शन 81 ऑफ आर्बिट्रेशन एक्ट में. नेक्स्ट 50, द क्वेश्चन वेदर अ स्टेटमेंट वाज रिकॉर्डेड इन द कोर्स ऑफ इन्वेस्टिगेशन इज अ क्वेश्चन ऑफ फैक्ट और लॉ. ये क्वेश्चन ऑफ फैक्ट है. बी इज द आंसर. Next 57, necessity rule as to admissibility of evidence is applicable when the maker of the statement is dead or has become incapable of giving evidence. बिल्कुल ठीक है. ये कहाँ मेंशन किया गया? सेक्शन 32 के 1 में. is a person who can be found but his attendance cannot be procured without unreasonable delay expenses, या फिर is a person who cannot be found. All of the above. D is the answer. Next 58, secondary evidence of document means copies of the document या फिर ओरल अकाउंट और कंटेंट्स ऑफ डॉक्यूमेंट. बोथ हो गए ये. सी इसका आंसर रहेगा. बोथ ए एंड बी. सेकेंडरी एविडेंस के बारे में कहाँ मेंशन किया गया? सेक्शन 63 एंड 65 ऑफ एविडेंस एक्ट में. नेक्स्ट 59, ए विल इज रिक्वायर्ड टू बी प्रूव्ड बाय कॉलिंग एट लीस्ट वन अटेस्टिंग विटनेस व्हेन इट इज रजिस्टर्ड या फिर अनरजिस्टर्ड या फिर एडमिटेड. ऑल ऑफ द अबव. इन एनी केस one attesting witness is required for proving a will. का मेंशन किया गया सेक्शन 68 of Evidence Act. Next 60, any person in section 106 Evidence Act refers to a party to a suit, stranger या फिर a person who is not a party to a suit but interested in outcome of the suit. A party to a suit, obviously A is the answer. Next 92, a retracted confession can be solely made the basis of conviction. No, cannot be solely made the basis of conviction. बिल्कुल ठीक है ये. Cannot be solely made the basis of conviction unless the same is corroborated. C इसका आंसर रहेगा. Next 93, a confession to be inadmissible under section 25 of the act must relate to the same crime for which offenders is charged, या फिर may relate to the same crime for which offender is charged, या फिर must relate to another crime. सेम होना चाहिए ऑब्वियसली. और देखिए एक्ट लिख दिया, कौन सा ये एविडेंस एक्ट की बात कर रहे हैं. और अब जो 25 एविडेंस एक्ट क्या कहता है कि पुलिस को दिया कोई भी कन्फेशन रेलिवेंट नहीं होगा, वो सेम क्राइम से रिलेटेड है, और किसी अदर क्राइम से है तो पुलिस को दिया कोई भी कन्फेशन जो है रेलिवेंट नहीं होता है. तो कन्फेशन चाहे वो एक सेम क्राइम का दूसरे क्राइम का, उससे क्या फ़र्क पड़ रहा है. कन्फेशन कन्फेशन है, कंफ्यूज कर दिया यहाँ पर. ये क्वेश्चन प्रॉपर नहीं है ये. नेक्स्ट 94, एन unjustified and unexplained long delay on the part of investigating officer in recording the statement of a material witness would render the evidence of such witness unreliable. A is the answer. This is 8. Under section 18 of Indian Evidence Act, the admission of which of the following person is not admissible against the other? One of the plaintiffs or defendants? One of the defendants. B is the answer. Next 26. Which of the following statement is correct? A confession made by the accused to the police is relevant. No, it is wrong. It is mentioned in section 25 कि वो irrelevant होगा. Confession made by accused in police custody to magistrate is not relevant. ये relevant होता है as per section 26. A confession made by an accused in police custody and discovery made from the information received from confessions. Both confession and discovery are relevant. No, discovery होगी वही relevant होगा. So much of such information in section 27 it is provided. So none of the above is correct. D is the answer. Next 38. What is the maximum number of witnesses which can be produced in a case? No limit. D is the answer. Number of witnesses is irrelevant. Weight होना चाहिए उनके एविडेंस में, है ना. कहाँ मेंशन किया गया? सेक्शन 134 एविडेंस एक्ट में. Next 52. Which section of Indian Evidence Act is based on English doctrine of res gestae? That is section 6. B is the answer. Next 60. In relation to relevancy of character in civil cases, which of the following is not correct? Not correct पूछा है यहाँ पे. It is not relevant at all. नहीं जी, relevant होता है when affect damages a character is an issue, it appears from the fact otherwise relevant. A इसका आंसर हो गया. ये कहाँ लिखा हुआ? सेक्शन 55 एविडेंस एक्ट में. Next 78. Pakistan Narayan Swamy versus Emperor is a leading case on Dine Declaration. A is the answer. Next 83. Section 112 of Indian Evidence Act provides that the child would be treated as legitimate if after dissolution of marriage she has been born within 280 days. C is the answer. Next 92. In joint trial, the evidentiary value of confession of a co-accused affecting himself and others has been discussed by the Supreme Court in Kashmir versus State of MP. A is the answer. और ये देवरमन नहीं है, देवमन है. यहाँ पर ये स्पेलिंग मिस्टेक्स बहुत करते हैं. ये इसका आंसर रहेगा. ये राम भरोसे वाला केस सेक्शन 15 पर है. देवमन वाला किस पर है? ये सेक्शन 27 कॉन्स्टिट्यूशनल वैलिडिटी पर. Next 58. Proving of handwriting is provided in Indian Evidence Act by the opinion of experts या फिर evidence of a person who is acquainted with the handwriting. Both A and B. D is the answer. Next 59. Section 26 of Indian Evidence Act provides no confession made by a person in police custody is admissible unless made in immediate presence of magistrate. तो A and C जो है दोनों ठीक हो जाएंगे. D इसका आंसर रहेगा. Next 60. The term evidence means and includes oral, documentary, electronic, all of the above. D is the answer. Section 3 interpretations in Evidence Act it is provided. Next is 90. Under section 59 to 60 Evidence Act, the oral statement means all statement made before the court by the witness या फिर all statement made before by police या फिर which a witness heard to say. कोई भी oral statement तो इसमें कुछ भी नहीं बना. ऑल ऑफ दी बदल दिया, नन ऑफ दी आना चाहिए था. इस क्वेश्चन को डिलीट कर दिया गया था. नेक्स्ट इज 91. अंडर द एविडेंस एक्ट कोर्ट इंक्लूड्स ऑल जजेस, मैजिस्ट्रेट, आर्बिट्रेटर्स. आर्बिट्रेटर नहीं होते, तो ए एंड बी. डी इज द आंसर. सेक्शन 3 इंटरप्रिटेशंस में ही है ये भी. नेक्स्ट 92. Admissibility of contents of electronic record may be proved in accordance with the provision of 65B and Evidence Act. C is the answer. Next 93, which is not a public record as per the provision of Indian Evidence Act. Document forming acts and records of sovereign authority, ये तो है पब्लिक रिकॉर्ड फॉर्मिंग द एक्ट्स रिकॉर्ड्स ऑफ ऑफिशियल बॉडीज ट्राइब्यूनल, ये भी है. डॉक्यूमेंट कोरस्पॉन्डेंस फ्रॉम एडवोकेट नोटरी ऑफिसर्स, ये नहीं है. डॉक्यूमेंट सर्कुलर्स ऑफ यूनिवर्सिटी ऑफ दिल्ली, ये भी है. सी इसका आंसर रहेगा. एक्सरसाइज 4, एग्जामिनेशन इन चीफ इज कंडक्टेड बाय. देखिए जो क्वेश्चन है कंट्रोवर्शियल था, ये इसको जो है डिलीट कर दिया गया था. कोर्ट ही करवाता है वैसे तो. Next 25, who is prevented from being testified under section 118 of Indian Evidence Act? Lunatic who cannot understand, yes he is. Extreme old age who cannot give rational answer, yes he is. A tender age person who cannot give rational answer, yes. All of the above हो गए. जो समझ सकता है वही विटनेस दे सकता है. डी इसका आंसर रहेगा. Next 31, any confessional statement by the accused given to a magistrate is admissible obviously. ए इसका आंसर रहेगा. नॉट एडमिसिबल तो बनेगा नहीं. बाकी ऑप्शन देख लेते हैं. चैलेंजेबल, नो नो नो. नेक्स्ट 42, कश्मीरा सिंह वर्सेस स्टेट ऑफ पंजाब इज लीडिंग केस ऑन. ये इनमें से किसी पर भी नहीं है. डी इसका आंसर रहेगा. कश्मीरा सिंह वर्सेस स्टेट ऑफ एमपी जो है ना, वो है कन्फेशन ऑफ को एक्यूज्ड पर इन एविडेंस एक्ट. थोड़ा सा ये इन्होंने ना ट्रिक क्वेश्चन बना दिया है, पंजाब लिख दिया है ताकि कंफ्यूज हो जाए बच्चे. नेक्स्ट 54, इन सिविल केसेस इंडियन एविडेंस एक्ट बिस्टोज बर्डन ऑफ प्रूफ ऑन. पिटिशनर पर होता है पहले तो ऑब्वियसली. ए इसका आंसर रहेगा. नेक्स्ट 77, डाइंग डिक्लेरेशन मस्ट बी मेड बाय डाइंग पर्सन इन हॉस्पिटल या फिर डॉक्टर हु इज ट्रीटिंग द डिसीज्ड इन हॉस्पिटल, या फिर डिसीज्ड बिफोर डेथ, या फिर नियर रिलेटिव्स ऑफ डिसीज्ड. तो डिसीज करेगा बिफोर डेथ ऑब्वियसली, तो सी इसका आंसर रहेगा. प्रोविजन कहाँ है? सेक्शन 32(1) ऑफ एविडेंस एक्ट. नेक्स्ट 83, एनी क्वेश्चन सजेस्टिंग द आंसर विच द पर्सन पुटिंग इट एक्सपेक्ट्स टू रिसीव इज कॉल्ड एज लीडिंग क्वेश्चन. तो इस क्वेश्चन को जो है डिलीट कर दिया गया था. देखिए मिसलीडिंग लिखा हुआ है. लीडिंग क्वेश्चन कहाँ पर है? 141 एविडेंस एक्ट में. नेक्स्ट 86, द वर्ड केस यूज्ड इन सेक्शन 115 ऑफ द सीपीसी इज ऑफ वाइड import and it means any state of facts juridically considered, या फिर it includes civil proceedings, other suit and is not restricted to anything contained in this section to the entirety of the proceedings in civil court. Both A and B. C इसका आंसर रहेगा. 115 किसके लिए CPC में? रिवीजन के लिए. नेक्स्ट 90, इंडियन एविडेंस वाज enacted in 1872 एंड लागू कब से हुआ था? 1 सितंबर 1872 से. किसने ड्राफ्ट किया था सर? जेम्स स्टीफन. बी इज द आंसर. नेक्स्ट 37, ए कम्युनिकेशन मेड टू द स्पाउस ड्यूरिंग मैरिज अंडर सेक्शन 122 क्या है? रिमेन्स प्रिविलेज्ड इवन आफ्टर रिजोल्यूशन ऑफ मैरिज. बिल्कुल ठीक है ये. डज नॉट रिमेन, डज नॉट रिमेन, डज नॉट. ए इसका आंसर रहेगा. नेक्स्ट 38, विच सेक्शन ऑफ इंडियन एविडेंस एक्ट प्रोवाइड्स दैट एन अकम्प्लिस इज अ कॉम्पिटेंट विटनेस? दैट इज सेक्शन 133. सी इज द आंसर. नेक्स्ट 53, अंडर सेक्शन 118 ऑफ इंडिया एक्ट, यहाँ पर इंडियन एविडेंस एक्ट आना चाहिए. देखिए लिखा हो ना साक्ष्य अधिनियम, इधर यहाँ पर भी साक्ष्य की स्पेलिंग गलत कर रखी है. नहीं क्या बनाते हैं पेपर यार. A person is a competent witness if he or she is a major, not lunatic, and is not of extreme old age, is capable of understanding questions put to him and giving rational answer irrespective of age. मेजर की तो ऐसा कुछ नहीं है ना. तो डी इसका आंसर रहेगा. सेक्शन दिल्ली बता ही दिया 118 में है ये. नेक्स्ट 54, which of the following judgment is irrelevant under section 43 of Indian Evidence Act? जजमेंट ऑफ क्रिमिनल कोर्ट. तो बी इसका आंसर रहेगा. नेक्स्ट 77, a question suggesting the answer which the person putting it wishes or expect to receive is called leading question. B is the answer. Section 141 Evidence Act provides for that. Next 96, a dumb witness gives his evidence in writing in open court. Such evidence would be treated as an oral evidence. कहाँ मेंशन किया गया 119 एविडेंस एक्ट में. Next 97, under the Indian Evidence Act, which of the following is not a court? पर्सन लीगली ऑथराइज टू टेक एविडेंस ये है, जजेस है, मैजिस्ट्रेट है, आर्बिट्रेटर नहीं होता, तो डी इसका आंसर रहेगा. Next 22, one of the following statement is not true. Which one is that? Confession by one co-accused implicating other co-accused would be proved. ये ठीक है. कन्फेशन टू ए पुलिस ऑफिसर कैन नॉट बी प्रूव्ड, ये बिल्कुल ठीक है. कन्फेशन बाय अ पर्सन इन कस्टडी ऑफ पुलिस ऑफिसर टू एनी पर्सन इन प्रेजेंस ऑफ मैजिस्ट्रेट कैन बी प्रूव्ड, ये रॉन्ग है. कन्फेशन ऑफ पर्सन लीड्स टू रिकवरी ऑफ अ थिंग इट कैन बी प्रूव्ड, यस. सेक्शन 27 है, ये सेक्शन 25 है, ये सेक्शन 30 है, तो सी इसमें गलत हो गया. सी इज द आंसर. नेक्स्ट 23, कश्मीरा सिंह वर्सेस स्टेट ऑफ एमपी इज अ लीडिंग केस ऑन कन्फेशन ऑफ ए को एक्यूज्ड. सेक्शन 30 पर है ये, एविडेंस एक्ट. डी इसका आंसर रहेगा. नेक्स्ट 24, विच ऑफ द फॉलोइंग फैक्ट इज नॉट रेलिवेंट इन सिविल एंड क्रिमिनल केसेस. अंडर सेक्शन 8 ऑफ द इंडियन एविडेंस एक्ट, तो कौन सा नहीं है इसमें? कौन कौन से आते हैं? पीसीएम आता है इसमें, प्रिपरेशन कंडक्ट मोटिव, तो मोटिव या कंडक्ट प्रिपरेशन अटेम्प्ट नहीं होता, और डी इसका आंसर हो गया. नेक्स्ट 62, under the Indian Evidence Act, the character of a person is not relevant in which of the following cases? Previous good character of accused in criminal case, ये तो relevant होता है. Previous bad character in reply to good character in criminal case, ये भी बिल्कुल ठीक है. Character to prove conduct imputed in civil case, ये भी ठीक है. Character to prove conduct imputed in civil case, ये relevant नहीं होता है. एक्टर अफेक्टेड द अमाउंट ऑफ डैमेज इन सिविल केसेस, ये रेलिवेंट है, तो रेलिवेंट कौन सा नहीं हुआ? सी इज द आंसर. ये है सेक्शन 53, ये है 54, ये है 52 एंड दिस इज 55. नेक्स्ट 63, विच वन ऑफ द फॉलोइंग इज प्राइमरी एविडेंस? डॉक्यूमेंट प्रोड्यूस्ड फॉर द इंस्पेक्शन ऑफ द कोर्ट, ये प्राइमरी है, कॉपीज नहीं, सर्टिफाइड कॉपीज नहीं, फोटोस्टेट कॉपीज नहीं, सब सेकेंडरी हो जाएगा, तो ए इज द आंसर. कहाँ मेंशन किया गया? सेक्शन 62 एंड सेक्शन 64 में ऑफ एविडेंस एक्ट. नेक्स्ट 80, इफ इट इज प्रूव दैट अ मैन हैज नॉट हैव बीन हर्ड फॉर डैश बाय दोज हु वुड नेचुरली हैव हर्ड ऑफ हिम इफ ही वर अलाइव, द प्रिजम्पशन अंडर सेक्शन 108 of Indian Evidence Act that he is dead. 7 years. B is the answer. Next 81. A dumb witness given his evidence in writing in open court. Such evidence would be treated as oral evidence. A is the answer. कहाँ मेंशन किया गया? सेक्शन 119 एविडेंस एक्ट में. Next 82. Which of the following is not a public document? बैंक बुक्स नहीं, ये तो प्राइवेट रहेगा बैंक का. पोस्टमार्टम रिपोर्ट ये प्राइवेट है. जजमेंट ऑफ हाई कोर्ट ये पब्लिक है. अगर मेंशन किया गया रिपोर्टेबल है ना, रजिस्टर्ड सेल डीड ये प्राइवेट है, तो इस क्वेश्चन को डिलीट कर दिया गया था. यहाँ पूछना चाहिए था विच इज पब्लिक डॉक्यूमेंट, तो जजमेंट ऑफ हाई कोर्ट आ सकता था अगर वो यहाँ पर लिखा होता कि रिपोर्टेबल है. तो पब्लिक डॉक्यूमेंट के बारे में कहाँ पर बात की गई है? सेक्शन 74 प्राइवेट 75 में. Next is 7. A intentionally and falsely lead B to believe that certain land belongs to A and thereby induces B to buy and pay for it. The land after becomes property of A and A seeks to set aside sale on the ground that at time of sale he had no title. He will not be allowed to prove his want of title. Which section of the Evidence Act is applicable? Section 115. कैसे? That is estoppel. Rule of estoppel लग जाएगा यहाँ पर, तो C इसका आंसर रहेगा. Next 24. The question is whether A owes B rupees 10,000. Which of the following statement are relevant under? The fact that A asked C to lend him money. Yes, it is relevant. D said to C in A's presence and hearing, I advise you not to trust A. He owes B 10,000 rupees. This is also correct. A went away without making any answer. It is also correct. So all of the above, D is the answer. और ये कहाँ mention किया गया है? This is illustration G in section 8 of Evidence Act. Next 25. So much of such information, whether it amounts to a confession or not, as relates distinctly to the fact thereby discovered by the police, may be proved under Section 27. C is the answer. Next 26. When the court has to form an opinion upon a point of foreign law or the science or art, or as to identity of handwriting or fingerprints, or opinion upon that point, persons specially skilled in such foreign law, science, or he is so and so, so and so. This is under section 45. B is the answer. एक्सपर्ट ओपिनियन की बात कर रहे हैं ना, ये 45 में है वो. Next 63. Res gestae, relevancy of facts forming part of same transaction, is dealt under section 6. A is the answer. Next 74. A is accused of waging war against the government of India by taking part in armed destruction in which property destroyed, troops are attacked, goals are broken open. The occurrence of these facts is relevant as forming part in a transaction, though A may not have been present at all of them. Under section 6, B is the answer. This is illustration in section 6 in Evidence Act. Next 75. Section 110 of Indian Evidence Act deals with burden of proof as to ownership. C is the answer. Next 76. Section 113A of the Indian Evidence Act deals with presumption as to abatement of murder or presumption as to abatement of suicide by married woman. A is the answer. Next 77. In which of the following case offense of sedition was in issue? In Queen versus Bal Gangadhar Tilak, या फिर Nihendru Dutt Mazumdar versus Emperor Kedarnath Singh versus State of Bihar? All of the above. D is the answer. Next 23. Under the head subsequent conduct, which of the following type of conduct would be material? Change of life, evasion of justice, fear, trembling. All of them. D is the answer. And where is the relevancy of conduct is mentioned? It is mentioned in Evidence Act section 8. Next 28. Under which section of Indian Evidence Act admissions are defined? Section 17. A is the answer. Next 66. The Evidence Act came into force on 1st September 1872. D is the answer. Next 80. Admission can broadly be categorized into judicial, extrajudicial. D is the answer. Both A and B. Next 81. Section 66 of Evidence Act lays down a notice must be given before secondary evidence can be received under section 65A. This is correct. Notice to produce a document must be in writing. Yes. Order 9 Rule 15 CPC prescribes the kinds of notice to produce a document. No, this is wrong. So 2 are correct and all of them is not an option. So A and B both are correct. And this question was also deleted due to this reason. Next 82. Maxim res ipsa loquitur means a thing speaks for itself. A is the answer. Next 91. When the accused states, I will produce the share which I gave received in such and such robbery, which I have, this must be have, spelling mistake, which I have received in such and such robbery, which of the following are not admissible with regard to section 25? But in section 25, any confession given to police is not admissible. An admission that there was a robbery or admission that accused took part in it, या फिर he got part in a property, a statement where to the property is. So I would say this question is wrong and it was not deleted, but it should have been deleted. How? There is no admission in section 25. It talks about confession first of all. But let's say if it is mentioned admission here, so admission that there was robbery, it is not admissible. Admission accused took part in it is not admissible. That he got part of the property, not admissible. Statement as to where the property is, this is also not admissible. So all of them are not admissible. D is the answer. Next 39. The doctrine of res gestae has been discussed in which section of Evidence Act? It is section 6. B is the answer. Next is 40. When the liability of a person who is one of the parties to the suit depends on the liability of a stranger to the suit, then an admission by stranger in respect of his liability shall be an admission on the part of that person who is a party to the suit. It has been provided in which section of the Indian Evidence Act? This is section 19. C is the answer. Next 41. Judicial evidence means evidence received by court in proof or disproof of facts. Obviously, A is the answer. Next 42. Which of the following is not a document according to Indian Evidence Act? So, definition of document is mentioned in section 3, interpretations in Evidence Act. So, an inscription on a plate, on a metal plate or stone, this is a document. Map or plan, yes. Caricature, yes. So, answer is D, none of the above. Next 43. Presumption as to dowry death is given under which section? 113B. A is the answer. 113A is for presumption as to abatement to suicide by a married woman. Okay. 114A, no consent in rape cases. Presumption as to no consent in rape cases. Next 44. Which of the following is not a secondary evidence as per section 63 of Indian Evidence Act 1872? So copies made from the original by mechanical process which in themselves ensure the accuracy of the copy and copies compared with such copies. This is secondary evidence. Copies made from or compared with the original. This is or account of contents of document given by some person who has himself seen it. This is secondary evidence. Copy is not certified under 63. This is not. D is the answer. Next 45. A leading question may be asked in cross-examination. C is the answer. Where it is mentioned? It is mentioned in section 143 of Evidence Act. And about examination in chief, cross-examination and re-examination, it is mentioned in section 137. And order of these examinations is mentioned in section 138. And what is leading question? It is mentioned in section 141 Evidence Act. Next 46. Extrajudicial confession means confession made either to police or person other than judges and magistrates, or made to magistrate या फिर before judges. No, it should not be written over here. However, you can say it is an extrajudicial confession. Relevancy or admissibility can be seen later on. So A can be the answer. अगर आपको इसमें कोई कमी लगी हो, कोई सजेशन हो, कोई एडवाइस हो, कोई कमेंट्स हो, तो आप जो है कमेंट सेक्शन में जाकर भी लिख सकते हैं. वी ऑलवेज अप्रिशिएट योर कमेंट्स. एंड अगर आपको ये वीडियो अच्छी लगी और एफर्ट्स हमारे अच्छे लगे हो तो इसको जरूर लाइक कीजिएगा, शेयर कीजिएगा अपने फ्रेंड्स के साथ, सो दैट दे कैन कम टू नो अबाउट आवर चैनल एंड वो भी बेनिफिट ले सकें. एंड अगर आपको हमारे एफर्ट्स अच्छे लगे हो तो इन एडिशन टू लाइक एंड सब्सक्राइब काइंडली गिव अस अ सुपर थैंक्स. सुपर थैंक्स इज अ वे टू अप्रिशिएट द कंटेंट क्रिएटर. आप जो है जो भी कंटेंट बनाता है उसको अप्रिशिएट करने के लिए कोई भी अमाउंट जो है डोनेट कर सकते हैं. फ्रॉम मिनिमम स्टार्ट्स विद 40 रुपीज़ एंड काइंडली गिव अस अ सुपर थैंक्स. So friends, thanks very much for watching this video. Thank you.